May it please the court, my name is Jonathan Harwell. I'm here on behalf of the defendant, Daryl Rollins. If I could reserve 4 minutes of my time for rebuttal. We've raised a couple of issues in our brief relating to sentencing. I intend only to argue the second of those issues this morning relating to the denial of probation. I know the court has reviewed the briefs, but just to briefly remind the court of the facts, this was a conceitedly very sad and tragic case. Mr. Rollins was with two of his friends, went to Walmart. He was driving his friend's car. On the way back home from the Walmart, had his two friends with him, and had one of the friends had a 15-month-old daughter who was in a car seat in the back of the car. On the way back from Walmart, the car Mr. Rollins was driving, drove at a high speed, went through a stop sign, swerved to avoid an oncoming car, went over, I think, an embankment, crashed into a utility pole. The car burst into flames. Mr. Rollins got out and left the scene before police arrived. The two other men in the car also got out. There was only one door that appeared to be working. The father of the daughter went back. Everyone agreed heroically into the burning car in the effort to get out the 15-month-old from her car seat. Succeeded in getting her out, but because of the fire, she did die 8 or 9 days later. Mr. Rollins pled guilty. It was an open guilty plea to 3 of the charges, reckless vehicular homicide and 2 counts of reckless endangerment, really focusing today on the vehicular homicide. In the PSR and at the sentencing hearing, there were statements that we certainly do not dispute from family members as to the tragic nature, the loss of a young girl and the continuing impact that it had on her family, on her father, and others that knew her. The trial court imposed the maximum sentence on vehicular homicide of 6 years, imposed sentences on reckless endangerment, which were ordered to run concurrently. The issue, as I said, I'd like to address relates to alternative sentencing of probation. The court did note there were factors.
Well, before you get into that for me, please pardon me for interrupting. Judicial diversion was discussed in the trial court. It doesn't appear to me on your brief that you're raising an issue with respect to the denial of judicial diversion. Am I correct?
That's correct.
All right, so we're only addressing the alternative sentencing portion then, is that correct? Okay, very good, thank you.
There was a defense counsel noted he wasn't certain that diversion was appropriate, even though he had a diversion certificate. There was a subsequent hearing on an appellate bond. At that time, the state came forward with an indication that actually Mr. Rollins was never eligible for diversion. Okay, that's that's not an issue on appeal.
Thank you very much. Thank you.
Before denying probation, the sentencing court did notice there were a number of things in Mr. Rollins' favor. He had family, community support. He had an employment history. He had a glowing record, a glowing letter from his current employer. He had a lack of any serious criminal history. But ultimately, the court also noted he was a favorable candidate for probation pursuant to statute. But ultimately, the sentencing court denied probation on the reasoning that not incarcerating him would depreciate the seriousness of the offense. And that's the issue I want to get to.
Was that the sole basis upon which incarceration was ordered?
It was.
In the judicial diversion analysis, the trial court also analyzed the lack of deterrent effect that would have proceeded had diversion been granted. Are we to read anything into the trial court's analysis of the diversion factors when also considering the substantially similar probation factors?
I don't think so, in the sense that the trial court did explain exactly why it was denying probation. it walked. So essentially, there's 4 ways you could deny probation in this situation. He explained why 3 of them were inappropriate. There was no long history of criminal conduct. There was no measures less restrictive than confinement that had been frequently applied. And he repeated, I think, that there was no indication there would be a deterrent effect. So he relied solely on that not imposing incarceration would avoid or would depreciate the seriousness of the offense. So that was the only criterion that the trial court relied upon. So I think everything he said in that context was consistent with what he said in denying judicial diversion and probably in terms of picking the length of the sentence, but he reiterated it specifically in terms of the statutory considerations for alternative sentences as well.
So that then the conclusion would be that the analysis had to be made under the additional factors, the broader factors?
Yes, I agree.
Okay.
And to turn to those factors, and this is, as the court is as well as aware, and unfortunately I'm well aware, sentencing appeals are very hard because there is so much discretion granted to the sentencing court, and this court has been instructed under Buys and Caudle and other standards as to a extremely deferential standard of review. But there are certain circumstances in which a sort of mushy, hand-waving review takes on some actual substance. And when we're talking about the denial of alternative sentence on the basis of depreciating the seriousness of the offense, that's one of the circumstances the Supreme Court has given an actual standard that there actually has to be findings regarding. And that standard in Travis and Trent and Fields is, first, the circumstances of the offense have to be especially violent, horrifying, shocking, reprehensible, offensive, egregious. And secondly, the nature of the offense must outweigh all factors favoring probation. And that's what we're arguing here today, that there was no finding as to either of those, nor could there have been such a finding. I do think the sentencing court was admirably clear in explaining its reasoning for denying probation. He said it was doing it because probation would depreciate the seriousness of the offense. And then he said, and this is the basis of our appeal, so I will read it verbatim. I base that solely on the circumstances that we're dealing with the severe pain has been suffered Hazley in her short life and her father, which is going to go beyond the physical pain that he felt that day, continues to feel for the rest of his life. And so there are times that justice just requires, to avoid deprecating the seriousness of the offense, that confinement be warranted. And that is his explanation, and that is he says solely, the sole explanation for his finding as to depreciating the seriousness of the offense.
Almost every vehicular homicide case that we get involves ultimately a determination that the offenses were particularly reprehensible or horrific or whatever, justifying using the nature and circumstances of the offense to deny alternative sentencing. I mean, it's just every case is not every case, but so many of our cases centered around that factor. And it's due to the nature of the fact, I believe, that there has been an automobile tragedy in which someone was killed, and there's always some aspect of the homicide that's alarming because it's a homicide. But in this case, and I believe the trial judge cited to this, once you look at the actual damage inflicted in the collision, you have the additional aspect of the defendant running away. And does that not legitimately place the circumstances of this offense in a more horrific, especially violent, especially reprehensible, the Travis Hartley litany of factors, that puts this case beyond the average vehicular homicide case? So what do you say about that?
I think I'd say three things. One, that issue was certainly discussed at the sentencing hearing. There was impact statements criticizing Mr. Rollins for having left the scene. That's not what the sentencing court said, though. The sentencing court said the sole reason was the pain suffered by the decedent and by her mourning family. So the sentencing court did not, there was dispute as to whether or not Mr. Rollins could have done anything to help or why he left. Sentencing court did not rely on that in terms of making this a more egregious offense.
Mr. Harwell, though, aren't you asking us to conduct a de novo review here, though, because the findings weren't made?
Yes.
Then in a de
The
novo,
court could.
in a de novo review, then, couldn't the factor that Judge Witt is suggesting be considered by this court, even if the sentencing court didn't consider it?
I think that's correct, with one proviso, in that the Trent factors talk about the circumstances of the offense as committed. And I think that means, what is it about the vehicular homicide that is especially egregious? Not about, did the defendant act properly in the aftermath? I realize there may be a close connection, but when the crash has happened, he has committed the vehicular homicide. Whether or not he behaves admirably or reprehensibly in the hours or days after that, I think are...
Well, what about in the seconds after?
And I think that could make a difference. But here, there actually was a factual issue. The victim impact statements faulted Mr. Rollins for not saving the child. Defense counsel actually had testimony from one of the other men in the car that established there was only one working door. It was the driver's door. So once Mr. Rollins got out, A, he had to get out for anybody else to get out. And B, the other men were trying to get the daughter out from the rear passenger's seat.
Didn't one of them have to re-enter the car, though, to pull her out?
Yes.
I think maybe the factor that Judge Witt is asking about is simply just a failure to render aid, because it's not the case here that the homicide was complete upon the wreck. The victim died some 9 days later, right?
Yes, I think the facts would establish, though, there was no additional aid that Mr. Rollins could have rendered. The girl's father was going into the back. Both men were trying to get the child out of the car seat. Everybody got out. The girl's father went back. I guess Mr. Rollins could have declared that he was going to do it, but there certainly was nothing established that shows that his failure to be the one to go into the car made the situation any worse. And there was that dispute as to the facts, and ultimately the sentencing court, as I said, didn't resolve that in any way, because sentencing court focused solely on the harm to the family. And I think you ask, what am I asking the court to do? Certainly the one thing the court could do would be simply to send this back to the trial court for proper analysis under Trent, but I think that that's not necessary. I think this court has an adequate record to conduct a de novo review to look at the two prongs. There is, and this is the problem I think the sentencing court had, and the problem with this case. There's a horrific outcome, but that doesn't mean that the vehicular homicide offense that was committed was especially egregious. He sped, he ran a red light, a stop sign, he swerved to avoid a car, he crashed. That is criminal, that is vehicular homicide. He pled to it.
Is it not excessive? So you indicate that maybe it was speeding, but it could have been speeding twice the posted speed limit, disregarding traffic control signs, multiple passengers in the car, horrific injuries. All of those have been factors that this court has typically considered when analyzing a vehicular homicide under the need to avoid depreciating the seriousness of the offense, and where this court has sustained sentences of confinement in that. So how are those factors not showing that the vehicular homicide here is excessive? None of those have to be in place for a vehicular homicide to occur, and yet they did here.
I agree, they don't have to be in place, but I think there's a spectrum, and I don't really know how to address that other than looking at the cases the court has considered. There's a case, I think I cited it, I don't remember the name of it, a gentleman who sped over 100 miles an hour away from a police car, crashed into a lake, left his nephew to drown when he could have saved him. And that was especially egregious. There was I think the Oxendine case. There was speeding to get around another car because someone was in a hurry to get somewhere, crashed, killed 2 people. Twice as serious vehicular homicide. And this court said, actually, that's not especially egregious. So I think it's a spectrum on the first factor. And on the second factor,
You're getting into your reserve time, sir.
Even if this court considers this to be egregious conduct compared to other vehicular homicides, it also, in order to deny probation, has to find that factor outweighs everything else. And Mr. Rollins, I think, is greatly differentiated from many of the other defendants facing vehicular homicide cases in the things he had going for him. He was a favorable candidate. He had limited criminal history. He had a college degree. He had a stable employment. He had an employer who wrote a glowing reference for him. He had family that the court acknowledged, an unusual amount of family in the courtroom and community support. All of those things make it so that even if this court were to disagree with me and find this was an especially horrifying variant of vehicular homicide, I think that still would not outweigh those other considerations that would support an alternative sentence for Mr. Rollins. And I'll reserve the rest of my time for rebuttal.
All right, thank you.
May it please the court, Catherine Redding on behalf of the state. I think that this court can look at the trial court's findings regarding judicial diversion to the extent that they overlap with the factors for probation, because it really, I think that those factors play together, and I think it's important to note that when the trial court considered the judicial diversion factors, it did specifically note that the defendant's behavior after the crash in terms of running away from the scene was a circumstance of the offense. So to your question, I think that yes, this court can look at it all together. And I think that when this court looks at the record, it will see that this trial court reviewed the circumstances of the offense.
Is that, excuse me, the running away from the scene, is that a violation of the law?
The defendant was, I believe, initially charged with leaving the scene of an accident, so but that was not part of the plea deal. But I think that it is part of what happened here. And I think to Judge Greenholt's point, this vehicular homicide is not a situation where the defendant crashed the vehicle and the passengers were killed on impact. I think this was a case where the passenger, Ms. Hazley Roper, survived for 9 days and suffered horrific injuries. So it was not complete until after she passed.
I don't think I've ever seen a vehicular homicide conviction up on appeal where the trial judge said at some point, this is just another vehicular homicide. Therefore, I have to look at something besides the nature or circumstances of the offense if I'm going to deny alternative sentencing. I've never seen a case where that's happened. Every time the judge says, this is an horrific, the facts are horrific, this person died, didn't have to die, it's tragic, therefore the nature and circumstances of the offense, we have to deny alternative sentencing to avoid depreciating the seriousness of this offense. Case after case, we get that, and it's, as I explained to counsel, and I understand that's a function of a functional result from the fact that this is a homicide, but they're all homicides. And do we need to change the law about this to some extent? Because it's almost a wink and a nod at the nature and circumstances of the offense to sustain denying alternative sentencing.
I don't think so. I think that the standards that are set out in Trotter and Trent that require these additional factors in order to deny probation in a vehicular homicide offense, I think that those are sufficient to ensure that each vehicular homicide case where someone has requested probation, it's denied, that it is reviewed, and that trial courts can't just say the circumstances of the offense are sufficient to justify confinement alone, that this court reviews. I think that the existing case, I think that's a question for maybe the legislature. I think that in this particular case, the circumstances of the offense were sufficient on their own to justify probation. I can't really speak to other cases, but I can say that here we have a trial court that reviewed the circumstances of the offense, reviewed the defendant's criminal record, his social history, his present condition, the need for deterrence, the best interests of the defendant and the public, his potential for rehabilitation, and found that almost all of those did weigh in favor of judicial diversion or probation, some sort of alternative sentencing. But what the court concluded was that despite all of this favorable evidence for the defendant, the circumstances of the offense, that confinement was necessary to avoid depreciating the seriousness of the offense. And the court did find that the seriousness of the offense was greater than other vehicular homicide and reckless endangerment offenses. And the record includes substantial evidence to support that conclusion.
Well, in general, I mean, going back to Judge Witt's point here, it's not the case, is it, that all vehicular homicide cases result in incarceration?
No.
In fact, this court has affirmed on previous occasions a fully suspended sentence for vehicular homicide cases. Is that right?
I believe so.
State versus Ring, a reported case from this court in 2001, affirmed a fully suspended sentence of 8 years. So the law can be applied in different ways and for different cases could result in incarceration, but do you see any issue with the law as it stands here, affording the trial courts the discretion so long as the appropriate findings are made?
I don't see any problems. I think that the way that it's set up today is sufficient to allow for a case-by-case review where trial courts should be looking at this and should not just be granting probation, or I'm sorry, requiring confinement in every vehicular homicide case. I think that trial courts, I can't really speak to the trends across the state. All I can tell you today is that this particular case, the laws that are in place were sufficient to require this trial court to make additional, to impose confinement based on something more than just the elements of the offense. And I think that when you look at the record, you see that the defendant was childhood friends with both of his passengers. He had known Hazley Roper for all of her very short life. He was in the vehicle because he had gone to Mr. Roper's house. He had decided to accompany Mr. Roper, Mr. Hansford, and Hazley to Walmart on a domestic errand. The defendant made the choice to get into the driver's vehicle. Mr. Roper had gone into the store. The defendant got into the driver's seat. Mr. Roper, when he came back to the vehicle, saw the defendant in the seat and entrusted him to continue driving the car. entrusted him with his own safety, his friend's safety, his daughter's safety, safety of his vehicle, and the defendant failed to recognize what his responsibility to these people, to his friends, was. He approached an intersection, sped up as he approached the intersection, was driving 70 to 100 miles an hour, which is excessive on most roads. But on this particular road, the speed limit was 40 miles an hour, and then he intentionally ran a stop sign. His actions forced him to swerve to avoid oncoming traffic, and he promptly crashed the car into a utility pole. But then rather than helping his best friends and Hazley out of the vehicle, he got out of the car and he ran away. Just hopped out the door and left. The car was on fire. He left Mr. Roper and Mr. Hansford to get Hazley out of a car seat located in the back of the car when only one door could open. And we have testimony from Mr. Hansford that neither Mr. Roper nor Mr. Hansford were able to get out of the vehicle from the doors that were there. But it's really a stretch to say what would have happened had the defendant stayed, that the defendant would not have been able to assist in any manner, so therefore we can just forgive him for just running away and leaving his friends in a burning vehicle. There's really not enough in the record to say his presence wouldn't have mattered. But what we have is a defendant leaving his friends and a child who is stuck in a car seat, in a burning car, in the back seat, in a car where the doors don't work, and leaving them to fight their way out. The defendant's actions taken in combination shows that
No, it's okay. How about this? What is the state's position with respect to the procedural posture of the case? Is the record sufficiently developed that we could and should conduct de novo review? Or is this a situation where the court should remand the sentencing court to make the additional findings required by Trotter?
I think that this court can uphold for reviewing for abuse of discretion, this court can uphold. I think this court can also uphold conducting de novo review. I don't think that there's any reason to send it back to the trial court to conduct this again. But I think no matter how the court wishes to treat it, what we have in this record is sufficient to impose confinement based solely on the circumstances of the offense in this case. I think that this is not a run-of-the-mill vehicular homicide where somebody died and it's tragic, and that is tragic. This is something more, and this was an appropriate denial of alternative sentencing.
Your friend on the other side had mentioned that the defendant had very little criminal record. What was the criminal record?
It appears that his only prior was for driving on a suspended license, which the trial court, I think, acknowledged was not much, but was concerned that it was a driving offense, that this was also a driving offense, and that the defendant had entered a plea to that offense, I think, within a week of this accident.
Within a week of this accident? What was the reason the license was suspended?
That, I don't believe, is in the record.
It's not contained in the record?
No.
Okay. He was on probation at the time of this accident?
I don't believe so. I think the trial court made findings about that. I think he had been charged, but he hadn't actually entered anything as to the driving on suspended, so I don't think there was any resolution there. And I believe that there is an indication in the trial record that the defendant, at least the trial court, did not find any indication that the defendant was on probation. So this really is a case where if you look at it, you see that the trial court considered everything that it was required to do, found that most things did in fact weigh in favor of probation and alternative sentencing, but that it was the circumstances of this offense that justified the confinement. And I think that this court can uphold that decision by the trial court without too much difficulty. If there are no further questions, the state asks this court to affirm.
Thank you. 3 minutes, Mr. Harwell.
I have three short points. One is to point to a case that two of your honors were on, the Sheets case, which did have a recurring, if I'm remembering it correctly, did have a recurring driving problem. The difference in that case being the defendant had already, I think, received a charge or conviction for reckless driving.
The defendant was on probation at that time, yes.
Here, there was a driving offense, but it was only a license suspension. There was no prior indication of reckless driving. Second point, and maybe this is just a rhetorical point, all vehicular homicides are excessive and violent and horrifying. But that does not mean that all vehicular homicides, they cannot all be excessively violent and horrifying compared to each other. And I think that's essentially the tension here. It's an incredibly sad case, incredibly bad outcome that was criminal. But this court has to step back and compare it to how does it compare to other vehicular homicides, and is it egregious? Not just is this a bad one, not just is this worse than average, but it is horrifying and shocking when compared to other vehicular homicides. The final point I want to make is to talk about something Judge Witt brought up, which is to step back from Trent and Travis and Fields. As to the rationale, why do we have these sort of unusual in terms of sentencing appeals? Why do we have these two factors that have to be considered? And the reason is because the Supreme Court recognized, I think, perhaps correctly, there are times when the public, or certainly the sentencing courts, may have a different view of the law than the legislature. And this is, I think, this is why this court sees many of these is sentencing courts often feel there is someone who has died, there is someone who has caused that person to die. It feels really weird to tell them they can walk out of this courtroom. But the legislature has said that's actually an appropriate outcome that should be considered. And the way to deal with that, as Your Honor suggested, is take it up with the legislature. The way is not to distort the law or to make sentencing decisions that go over and over and over again contrary to the expressed decision of the body that's entrusted to do that, which is the legislature. No further questions. I'll rest on our briefs.
Thank you. Thank you both for your arguments today. Call the next case, please.